All right, so let's get started. Um, and I am Joe Hogan, Vice President of Building for AGC New York State. I want to welcome you to it's a series, what I will call Episode 5 of our Lunch and Brunch series that we've been doing in conjunction with our partners at Document Crunch. And this particular one will be about liquidated damages. Josh, if you want to slip to the next slide, we'll do.
Yeah, sorry.
So I'm joined, as usual, by Josh Bell. Josh is the Director of Industry Solutions with Document Crunch, and these programs have been pretty well received and pretty popular. So the one thing that I will note, and I'll turn it over to Josh, is this is a partnership between AGC and Document Crunch. I'll let Josh in a minute explain exactly what Document Crunch is, but it really dovetails nicely with the long-held service that AGC has been providing its members for reviews of contract documents and offering comment. And so what we've been able to do is take the product and program that Document Crunch has put together and added an AGC New York State specific flavor to a lot of the issues. And so doing this series of programs, lunch and learns, as it were, seemed a natural progression. So Josh, you want to talk a little bit more about Document Crunch, and then we'll get right into talking about liquidated damages.
Yeah, thanks, Joe. Document Crunch is a contract intelligence solution, and our mission is to empower everyone to understand what's in their contracts. So and I'll go to what's next is like a comprehensive review, like everything you would want to know in that contract. And then we also have like a project manager cheat sheet. So project, and it strips out a lot of the information that project teams, it's not relevant for them. So we provide that as a way to provide the information they need and a way for project teams to collaborate on that. So that's one thing. And since we're talking about LDs today, an example of that would be, so as a former in-house attorney, I would see just what's on the paper, like liquidated damages. I would be like, man, this is a nasty liquidated damages clause. And the PX of the project team would say, what you're not seeing, Josh, is that we have so much time in the schedule. Never say never, but we would have you really late. So our mission is to put that knowledge into the hands of the project teams, because the project teams have the knowledge of the project much more so than in-house legal. So if we can basically provide that information and get it into the hands of the people that need it, they can make better decisions, faster decisions, that sort of thing. So with that, before I go into what I just talked about in Document Crunch and how it helps, I have actually been on both sides of it. I was in-house counsel for a large owner and also for a large GC. So on the LDs thing, on the owner side, we were never looking to like max out LDs. That was a worst case scenario for us because it meant the project was late, and the underlying project, we as an owner stood to lose a lot more than the LDs could ever make us whole for. So the goal of having an LDs was to incentivize the contractor, not to max those out. That said, being on the contractor side, there are some best practices and guardrails around that I will talk about. So, for example, some of those guardrails I would want to see in an LDs. I actually am a fan of LDs because in a contract, because it provides certainty. It says, okay, so I can like sort of determine what the worst case scenario could be. Some guardrails around that would be a maximum cap on BLDs that could be assessed, and also like having that be the sole and exclusive remedy for delay. So there isn't LDs plus something else potentially. And the other thing, which was a nice to have, which is a grace period. Say whether it be 2 weeks or something like that before you would have to be late beyond the substantial completion date before LDs would be assessed. Because what I found is that, and this is both on the owner and contractor side, is that if you're not going to make the schedule like even close, that is one thing. I mean, it's very different though, like say that you're very close to completing substantial completion, but not quite there yet. So you shouldn't be punished basically by LDs being assessed when you're right at the end of the line. Different story that, okay, well, if you're coming up on the substantial completion date and there is no way you're going to make it, hopefully that's something that the owner and contractor have addressed earlier before that happens, but that would be a different scenario. Going into the document crunch solution. So this is the comprehensive review that reviews the entire contract. So it's going to identify all the things you see listed in the table of contents, and you can just click the hyperlinks to take you right to the topic. Since we're talking about LDs today, this is what the LDs provision would say. And on the left-hand side of the screen, or the right-hand, sorry, where you see the insights and sample language, the insights are the insights that we have provided. And as Joe mentioned, for you, they've been customized to be more New York specific. In the sample language, we are powered by Consensus Docs, so that is sample language from them that we provide. However, either of those things can be customized. So if you have your own like rationale or preferred language, that can be just swapped out.
You know, Josh, I think it's interesting. We've already had some questions, which we'll go into a bit in due course. But you know, your initial comment about generally preferring liquidated damages, I think gets to a real important, what is really kind of a first question. It's because I agree that I would prefer liquidated damages. The general view is that once liquidated damages are set, actual damages are off the table.
Yeah.
So if your document is silent on liquidated damages, then you have the specter of actual damages, and you've got to go through the whole process of determining what are actual damages. What are they not, and how much can they grow not to mention, potentially additional legal fees. But the general view is that that is a maximum. Now, there are things that I will see regularly in documents, and this is one of the things that can be picked up, is this effort to within the document say liquidated damages plus actual damages. And perhaps they put those into the documents related to what I would call direct impact costs for them, perhaps the additional designer fees or some other specific direct costs. And so one of the questions is, Josh, when you have the basic idea that liquidated damages set the ceiling, are there other actual damages that can be separately dealt with and assessed within the documents, or does the liquidated damage provision negate those other provisions?
Yeah, it should negate, and that's why I mentioned the sole and exclusive guardrail that I would work into contracts, because the actuals, the contractor has no control over what that could be. So, and usually no visibility, right? So the owner that I work for, that I'm thinking about a particular project, that there's no way to, one, it was not equitable to try to assess like actuals to a contractor, and also that contractor would have no visibility, and it would make them like upside down on the job like immediately. So back to the whole point of LDs were not something, the mechanism that the benefit of them on the owner side is to incentivize the contractor to finish on time, not to like max them out. So to your point, I mean, not just from the contractor's perspective, but all those things that you mentioned, like having to go through the process, incur legal fees to prove your actuals, that's not good for either. I mean, in my view. So I would rather have those LDs up front and negotiate up front and understanding what they are, and from a owner side and contractor side.
A related question that came up was the idea of actual damages needing to be approximated in order to determine liquidated damages, and whether or not you can assess liquidated damages in a punitive manner. Now, my view, my teaching has always been no, liquidated damages cannot be punitive. They have to approximate what actual damages might be. Doesn't mean they have to be spot on, but they have to be somewhere in the ballpark.
Yes. So the magic words that you see in LD provisions about this is not a penalty, and it has to be like some reasonable estimate, that is based on case law. And if it's punitive, it's not enforceable. So you, as an owner, don't want to be in a situation where it is viewed as punitive. And I, having been in those conversations about the calculation of LDs, basing that on actuals, and honestly, like being on the GC side too, working with owners, they would like say, well, our actuals are this. And I mean, it was way out of line. So we were like, okay, well, on both sides, like these are our actuals, but this is not reasonable to like push this on to a contractor. So we would look at it like, okay, what is the reasonable estimation of what the actuals would be, but in the context of this project and the profit that is stood to be made, what is a reasonable amount? And that's how we would get to that calculation. So, but I definitely hear you as far as like owners' expectations is like we should be able to recoup everything. That's not the way it works. So, yeah.
So a related question, Josh, and one that comes up quite a bit, is the idea of liquidated damages based on missing milestones. And my view of it is this: based on the idea that they cannot be punitive, they have to have some resemblance to what actual damages might be, and that you actually have to have been damaged. The only milestone missed that could justify a liquidated damage, in my view, is if there was supposed to be some degree of occupancy. In other words, I'm going to finish phase one, or I'm going to finish the addition so that the owner can move into that addition before I do a renovation.
Yeah.
But missing a milestone that is, based on an owner or their designer or their construction manager or program manager think should have been an appropriate milestone to gauge whether you're going to finish on time, then I would suggest and submit that that is not enforceable in that whether the owner is actually going to be damaged at the end is speculative. And so you can't really hold liquidated damages except where there's actual damage that applies. Your thoughts on that, Jeff?
I totally agree. Unless, like in your example, we did a good bit of healthcare work on the GC side, and it would make sense, like if an OR or something that was going to be used was that first milestone. Okay, that would be one thing. But those sort of milestone LDs, I would try to get that out of there because, and also it's something on the owner side that we would give on as well, because ultimately your goal is to finish the project. So you should have the ability to make it up and not have the LDs. And if the owner's goal, as I said, is to incentivize removing the LDs from that milestone, makes sense, because your goal is to get your project done if you're the owner.
So one of the questions comes up about a milestone, maybe including the delivery of owner furnished equipment or furnishings, storage and or double handling would be a cost that could be incurred by the owner. I mean, Josh, I'll get your thoughts, but my thought is, I guess if there is to be an actual damage that an owner could reasonably suggest, then the LD might be there. I think the more likely, however, milestone on that would be appropriate for liquidated damage is where there's going to be usage of it, because I would think the double handling is going to be more by the contractor than by but who knows? I think you're going to have to show some reasonable determination of that there will be a damage, and whether that's a liquidated damage or something else, I'm not sure. Josh, your thoughts?
I agree. Even though it's speculative, because you don't know what the damages would be. Let's take like a hotel, for example. So you can calculate based on occupancy that you predict what that's going to be. That gives you a go by of like what. In other projects, it's harder to determine. So that is sometimes a wag or a guess of what that would be. Other times you can like nail that down and actually tie it to your presumed actuals. But you know, the whole concept behind LDs is that you are setting it up front, so you don't have the benefit of hindsight, so you don't know down the road what it could be potentially. So yeah, I mean, that is I think it is a best guess of what it could be. And it's also something that's negotiated by the parties up front. So, you know, another thing to your point about like the phase, not the no harm, no foul approach, is that if the owner, and I say it speaking from like a trade partner or sub view, is like if the owner does not assess LDs, then there should be no LDs against you. That was always my thought, is that, you know, and also you should only be responsible for your proportionate share of those LDs that directly were caused by your work or by your delay.
One of the things from a practical standpoint as well, and I'm seeing this in documents, is one of the values, I think, of getting a good read of this, is I'm seeing more and more damages, whether they're specifically called liquidated damages or something else, in documents. I'm seeing them, for the owner furnished equipment. I'm seeing them for missing job meetings. I'm seeing them for asking too many RFIs that someone thinks that maybe you should have been able to answer otherwise. From a practical standpoint, it really doesn't do a heck of a lot of good for a collaborative effort. It does a heck of a lot of good for a lot of attorneys. Sorry, attorneys who are on the and because you've really set it up for a lot of cross claims. Last month, we did the program on force majeure. Obviously, these kind of things come into play here. But one of the questions I often ask on these kind of milestone issues or these other weird damages is that door needs to swing both ways. In that, okay, so owner, if you're a designer and this is a job meeting or a specific sub engineer, a structural engineer or mechanical engineer is supposed to be at a meeting, doesn't make it, and we've wasted time. If I'm forced to ask a lot of RFIs because of the documents, do I get damages? If I'm there ready for that owner furnished equipment and I have folks ready and it's not delivered on time and that causes me issues, how does that swing, both ways is one of the questions. And really, do you want to get into that kind of a tit for tat approach to project management? I think is a practical question that needs to be thought about on this. Josh, any thoughts on that?
Yeah, I totally agree. I mean, that sets up like an adversarial relationship from the jump. So if you have LDs tied to other things, like you mentioned, submittals, or I've seen them like tied to key personnel to avoid like bait and switch type of thing, I think that is not a good collaborative approach from the get-go. Honestly, like, if from an owner's perspective, if you have those concerns about the contractor that you're working with, that's probably a bigger issue of like, I think it's a better approach to be collaborative, and whether it's working with the owner or owner rep or whomever to try to say, hey, what do we need to do? And if there's an issue like with submittals or key personnel, how can we address that outside of having LDs? One thing too, I wanted to mention, if there are LDs for delay, to your point about swinging both ways, there should be a carrot and a stick. Like if I'm early, there should be a bonus that I can achieve. If you want to incentivize me to be early, why not give me that? Because ultimately that is probably a lot less than what you stand to gain from it. And back to that point of, you know, as an owner, you want your project done on time. That is your main driver. So why not incentivize me with a bonus? So that was one that I would always ask for. If there's LDs, to say, okay, well, what is the incentive? Whether it's a bonus or greater sharing of savings or something like that.
Just playing devil's advocate a little bit, Josh. This is a question I get a lot. First of all, there is no requirement to, there are folks that think if you're going to have liquidated damages, you must by law have a bonus provision. And to my knowledge, there is no such requirement. The one caveat I would make relative to a bonus provision, it may depend on the way that you are procuring in a contract. If you're procuring in a hard bid world, particularly in a hard market, aftermarket may be a little bit less of an issue. But in a hard market, contractors who are bidding the work are going to bid based on getting the maximum bonus. Mm-hmm. And so every day they don't get the bonus becomes a liquidated damage in point of fact.
Right.
And so, Josh, question on that. Is it easier to defend against being charged a liquidated damage than to defend not being paid a bonus?
I would say the LD, just because, I mean, like you said, there are so many bonuses are a little bit squishy. So there are so many factors that could go into that. Also, now I'm going to talk out of both sides of my mouth. On the owner side, I would say, well, I'm hiring you to complete on time. So why should there be a bonus? I heard that a lot too on the contractor side from owners. And I was like, how dare you? Where it was successful was with the better owners that were more collaborative, that were looking to get their job done like as quickly as they could and were more than happy to pay a bonus.
Okay. One other point that comes up, and it gets down to, and you talk, Josh, about the share. One of the things to watch out for, in New York State, of course, we have the Wicks law, and so you're going to have, in many cases, you are going to have multiple prime contractors. You're going to have a separate mechanical contractor, a separate plumbing contractor, and a separate electrical contractor. And every once in a while, an owner may throw in a separate roofing contractor or site contractor. And one of the issues that comes up, and there are a number of ways to slice and dice this as to how this is going to be done. But if an owner determines that their liquidated damages, we'll just throw it out there, $1,000 a day, just because there's equal fault by 4 primes that would cause the lateness, although that's an interesting thing to do that, doesn't mean that their liquidated damage all of a sudden jumped to $4,000 a day.
Right.
That was punitive, right? So, Josh, how would you look at it? Because I don't typically see it clearly spelled out in the documents, but maybe you have, that there's going to be a pro rata share, assessed, based on level of fault. Is it equally shared? Is it shared, based on fault? And what happens in that regard when you've got multiple contractors, all with the liquidated damage penalty, and the overall project is late?
Yeah, excuse me. That onus is on the owner to show, and if that is not in a contract about what you just said about the pro rata share, I would try to get that in there, and that onus would then shift to the owner to show that it was my fault, basically. And the other thing I would watch out for I know this isn't on delays, but it's related, is anything related to like concurrent delays or something like that. So it's not like, okay, well, other contractors were 99% at fault, but because I was 1% at fault, you're going to assess the entire thing to me, or you can. So that's another thing, because I think that really goes to like a fairness argument to say, why should I be dinged for something that is not my fault or I don't have control over? And a lot of times that work is, in the critical path of my work. So if that's not done, then the clock really shouldn't start ticking on me.
And so, kind of a related issue with that, because I've heard this, before, and you've somewhat answered it. But I know, for example, that the switchgear, we know supply chain issues. I think we're somewhere around 100 weeks now out, and I've got a separate electrical contractor, and because the switchgear ain't coming in on time, there's no way that the owner is going to be able to obtain beneficial occupancy by, we'll just throw out a date, January 1 of 2024. It's going to be a minimum of 30 days late. And so because of that, I, as the general contractor, well, there's no incentive for me perhaps to work to finish by January 1 because it's not going to be ready anyway. Now, forgetting the idea of force majeure and maybe the defenses that the electrical contractor has, but what kind of danger does that put a GC in, or any other prime, to think the pressure is off and therefore I'm not going to be ready and perhaps subject myself into having to defend against liquidated damage?
I think that sours the relationship with the owner. And in that situation, I would be proactive, or I would recommend being proactive, because if you go to the owner and say, hey, this switchgear is going to be 30 days late or something, but I am going to do everything I can to get as the work ready and in order and all of that, because you never know. I mean, that switchgear could arrive early. So if you're not ready to go because you're like, well, it's not going to be here anyway, that has potential to sour that relationship.
Josh, I think we can probably move on
Okay.
to slide if you wish.
And
if there are, by the way, some questions have been typed in. There was one, as you switch to the next slide, there was a question about, maximum listed for liquidated damages. There is no statutory limit that I know of on liquidated damages. I've seen LDs for $250,000 a day on a project. It was justifiable and probably enforceable. There's no statutory limit. It just has to bear resemblance what actual damages would be. It can't be punitive.
yeah, Yeah, I mean, that you kind of have to take that. I mean, that's healthy, for sure. But in the context of the project, it might make sense, you know. But I think it also not just the value of the overall project, but the value of your work and what your stand to profit from that. So I think that back to the whole conversation about actuals versus LDs, there needs to be like some correlation, or if it's totally unreasonable to ask a contractor for the LDs, that doesn't make sense. I mean, you have to look at it as, okay, what is the profit this contractor stands to gain, and you use that as a starting point. So the next thing I mentioned earlier, like the comprehensive review that is going to tell you everything. We have, think now, 44 different things that we're looking for in a contract. Some of those things, like that guys like me care about, like dispute resolution and waiver of jury trial, project teams don't need to know that. So we have developed a project team cheat sheet that is going to provide just the information that the project teams need to know. And since we're talking about LDs today, the very related thing would be delays and how that's handled. So that's why that is highlighted. But the idea here too is that one problem that, or challenge that I think is on the owner and general contractor side, is that not everybody is maybe on the same page. They're not working from the same document or same draft. That is very common. So our goal here is to bring everybody kind of out of their silos and together, so they can collaborate and say, okay, well, the delay provision is here. It says we get time but not money, something like that. So then they can sort of assess that in project, that is, about, okay, in the context of this project, we would be okay with that, we're not okay with that, so on and so forth. So that is the delays provision that we would link, and it would link you to exactly what that is. In this case, it's going to say you're entitled to time. It doesn't preclude a claim for money. So that would be good to know, because other contracts are going to say you only get time and not money, or you don't get either, or you get both, or whatever the case may be. Or they may sort of slice and dice those delays depending on what they are, like force majeure, as you mentioned earlier, Joe, may be handled differently than, say, like an owner caused delay.
I think one of the interesting things, Josh, as we now on episode 5 here, is the interrelated nature of these things, which is why I think that having a good cheat sheet is important. So in other words, if I've got liquidated damages, I need to know what those are. I need to understand what those liquidated damages are, and where all those damages are, and are they negating one another? Are there other problems with that? But at the same time, I also need to know what is the force majeure provisions say? What are my abilities to get at least time out of it, so that I remove the pressure on the liquidated damages, or any damages for that matter. And then I fall back to the overall delay provisions and the delay damage provisions, and we discussed that in previous But then also, most importantly, notice. That was the first one we did, right? I better be paying attention to my notice provisions, right?
Yeah.
And so, the importance of assessing these risks and understanding what they are and what they aren't, where you can, by the time you if you're a PM, you get to it, well, the negotiation may have been over on the provisions. So you have to deal with those, obviously knowing this before as you're in the negotiation, helps with that process. A lot of times when I'm doing, the spec reviews on the public jobs where I'm sending the letters, I'm pointing out the issue of liquidated plus actual damages. I'm pointing out the milestone issues, and many of you have seen that before, right? But these are things that you really need to know and be focusing on, understand where the dangers are, and kind of have an idea in your head once you know what those dangers are. How do I mitigate them or avoid them altogether? And I think that's one of the things that becomes valuable to seeing those cheat sheets, to seeing that information right there in front of you in an easy way to make those assessments and prepare for managing your jobs. And so I think this is kind of the aim of our relationship with Document Crunch, but also the aim of doing these Lunch and Crunch series, really get you thinking in this regard.
Yeah.
Go ahead, Josh.
Go.
No, I was just going to make sure, remind folks that if they have, any questions, type them in. We've got a little bit more time to go, and so we'll try to answer them. But certainly, we're always available for questions afterwards as well. Josh, you were going to say something.
Yeah, I was going to say I totally agree. There's a lot of interplay between these provisions, so that knowing that, as you said, understanding what's in there and how that ties to delays, tied to LDs and notices, stuff like that is very important. This is the single most negotiated and scrutinized topic in construction contracts. So I would say, honestly, on the owner side, we expected it because this will be the first thing that we would expect a contractor to push back on, is to say, okay, milestones was one that was always like, okay, well, if it wasn't a milestone that wasn't going to be like, there's no like beneficial use or occupancy, that was one, frankly, we would concede, because back to the point of like, okay, well, the LDs are to incentivize contractors to finish the job, right? So why should there be LDs tied that cannot be recovered to a milestone that isn't going to give us what we need anyway? So back to this on the cheat sheet, same thing as before. The rationale, insights, and sample language are right there. And also you can just jump, you can see like next similar provision. So you can quickly jump to the next provision dealing with delays or anything like that that's related. So that helps you like navigate the contract, because you're like, okay, well, what else do I need to know in this contract? So that's going to help you too.
So I have a question. This is a DOT question. DOT lane closure, low flow traffic area to begin with no backups and or impacts to traveling public. LBs containing contract for a certain number of days of lane closure. Lane closure use more days than allowed. If no impact to traveling public and no additional cost to DOT, should LDs be applied? I think it goes, goes right back to it. It becomes, the idea of that closure and what was the impact, is if it turns to be what I would consider a punitive thing. We're just going to put that out there so that we can make you, just pay and get your attention by slapping you with it, as opposed to covering a damage. My view has always been that those kind of things are not appropriate, not enforceable. Although there's always the question of, you bid it, you bought those terms and conditions, right? But that's the issue that I have with that. Josh, your thoughts?
My thought would be that would be on the public side. So my first reaction would be to look at the statute and see if there's anything there that addresses it. On the private side, private owners or parties can do whatever they please. And then, so I don't know how that would play out. I mean, have you seen that, Joe?
Well, I've not seen it, but I think that it's one of those issues. I think that the driving question is no impact to the traveling public, right? And so is that is that speculation that there was no impact, right? Or is that in fact there was no impact? And I think the issue is beyond whether there was actual damage. I think I could argue that, but the question is, if my basis of the argument is no impact to the traveling public, to my mind, once you've signed that contract and you've accepted that, then your ability to question whether there was impact to the traveling public may be gone.
Yeah. I mean, that's kind of where my mind was going to, because I would think it would be very difficult to show or to prove that there wasn't an impact. I mean, so to your point, I mean, that is kind of the principle behind LDs, is that you don't have to go there because you're agreeing up front. These are the damages that apply. So I think that cuts both ways. I mean, whether but then again, I'm going to talk about the other side of my mouth. The no harm, no foul. So okay. So I'm just going to make up something ridiculous, but what happens if a meteor hits that highway? And yeah, of course. So there is no traffic. So why should LDs be assessed?
Yeah, I think that becomes an interesting question. And I think the issue is that once you bid that job, I think it becomes more difficult to argue the point. Now, here's the next question, an interesting one. Best practices to negotiate LDs on public work? Is this something a contractor can do? Can you negotiate LDs on multiple prime projects? Well, by and large, now we're getting into the competitive bidding laws of New York State, right? And these are terms and conditions that, number one, you cannot qualify your bid. I mean, I've seen contractors attempt to say, well, this is my bid, but only if you remove the liquidated damages. Well, that means your bid should be automatically rejected. Negotiating terms and conditions like that after the fact are generally viewed to be illegal, and could render, in my view, your contract to be a nullity. Because here's the question: if I'm bidding on a job and I feel I have the ability and have given the ability afterwards to negotiate those LDs away or to change them, then if I'm another bidder, if I'm the second bidder, I'm going to say, wait a minute, if I was had the ability to negotiate those away, then I would have been low bidder. I factored that into my bid.
Right.
And so on public work in New York State, now this is on a hard bid, competitive bid project, as opposed to perhaps a design build approach where it's a more progressive selection process. But on a hard bid job, I would say absolutely not. Now, can you negotiate on it again on multiple prime contracts? It's less of a negotiation and more of a determination of what the issues are afterwards, as to whether you were at fault, whether you can be assessed fully, again, based back to those basic parameters that we said. As I said, if it's more than one prime delaying the owner the same day, well, the owner doesn't all of a sudden get to be unjustly enriched because he can assess the same liquidated damage on each prime contractor. He can only do a pro rata share and get to the top, because the owner in this case has set the maximum. They said my damage will be $1,000 a day.
Mm-hmm. Yeah. Yeah, that makes sense. That's been my experience or assumption on those hard bid jobs. Honestly, I look at that as more of an awareness exercise than, hey, what can we negotiate? Looking at it from through a contractor's lens, that was always. I will say one thing actually just popped in my head on this, applies on the private side, but if the part, and I would see this a lot, like if the parties say, well, there's no LDs, they would put NA. And I would say, let's put $0, because later that could be interpreted NA, you're electing actuals in lieu of LDs, not LDs $0.
That's an interesting point, right? Is $0 on liquidated damage versus really striking the clause, right? Mm-hmm. If I'm an owner, I would probably rather strike the clause completely, right, so that I can on actual damages, rather than a suggestion that I've set the bar at zero damage. That's an interesting point. So we're a little bit beyond time, which is great. We don't mind this. You see the QR for a demo on Lunch and Crunch. You've also got the emails for myself and Josh if you have additional questions. And of course, as always, for our members, on these kind of things, as we like to say, call AGC first. And then we'll go from there. And so I look forward to talking to folks that are on this, and hopefully seeing you in the next one. We're taking March off because it's during the AGC convention and Con Expo. And so forget what the topic's going to be, but we'll see you again in April. Thank you all very much.
Thank you.